Hi everyone, welcome to week five. Okay, can you all hear me? Thumbs up if you can hear me. Yeah, okay, good. All right, welcome to week five, the last week before a very well-deserved lecture recess. So just a couple more days, hang in there, and then you'll be free to relax a little bit. Obviously, you guys have still got to work on your research project. I appreciate that, and probably other assessment over the recess, but the break from lectures and workshops should give you a little bit of time to just recuperate a little bit before carrying on for the remainder of the semester. Okay, so a couple of things, just a reminder that the project plan is due tomorrow at 11:59 p.m. And I don't want you guys to be panicking about that. I know that you're all going to be in the final throes of putting it together, but I just wanted to remind you that the purpose of that is really one of feedback. It's really to help me provide you with feedback on the title, the structure, the sources that you've currently collected and the sources you might need in the future, and your time management. And because of that, if there are any things that you want me to specifically address, please put them in brackets. So you can put questions or you can provide comments, and I will give you feedback directed at those particular comments or questions that you've placed in brackets. It's obviously got value attached to it just so that everybody does it and everyone receives feedback, but its primary purpose is one of feedback. It's a feedback exercise. So just before we kick off with the workshop, and we're going to go straight into the workshop activity this week because I've got a couple of things that I wanted to chat through with you about finding sources and how to find abbreviations and things like that. I just wanted to know how useful you have found being made to do the project plan, whether it's actually helped you in terms of your preparation and getting you on the right track. So let me just launch a poll. It's completely anonymous. Okay, so I'm just launching it now. So to what extent has preparing the project plan helped you with your time management and the structure of your research project? So 1, it's really helped. 2, it's helped in some areas or ways. 3, it's not made much difference. And 4, I found it unhelpful. Obviously, this information is quite useful because we can always consider redesigning the unit to some degree. I mean, there's certain things that we have to cover to make sure you guys have got the skills that you need and it sits within the appropriate place within the whole law degree curriculum, but we can certainly tweak things based on feedback that you give us. Excuse me, I'm just going to turn my mic off because I'm going to Don't worry, it's not COVID. It's just something stuck in my throat from dinner, which I kind of threw down my neck because it was late. Okay, so we're just waiting for one more person. Okay, so I'm closing the poll now. And I'll share the results with you. So you can see that about 67% of you found it really helped. 22% said that it had helped in some areas or ways, and about 11% of you said that it didn't make much difference. Fortunately, none of you found that it was unhelpful. So I think what we can do is we can look at the first 2 categories and say that for the vast majority of you, it's at least giving you some help towards your final project. And of course, you might feel differently also once you've received feedback as well from me in the next couple of weeks. Okay, thank you for that. All right, so I would like to get straight on with the workshop task. So in the workshop, one of the things that you needed to do was identify the case of Coco and the Queen and locate it on OSLI, Westlaw, and Lexis Advance. So firstly, what does CLR stand for in the citation? So when it says whatever it is.
It stands for the Commonwealth Law Reports.
Yeah, absolutely. And I'm sure that you guys know most of the normal abbreviations. Okay, so most of you know the basic abbreviations for the most common or the most notorious law reports, but in case you don't know where to find a law report, you don't know what it stands for, there's a couple of ways that you can find out. So I'm just going to show you those now. So I'm just going to get the internet up, if I can find it, wherever it's gone. Safari? I think it's Safari. Let's have a look. Okay, so there are a couple of ways that we can, don't know why that is only share. Can you guys only see a tiny bit of that? Yeah, that's strange. Okay, let me stop sharing and try and fix that. I don't know why it's doing that. That's really strange. Let me try again. Sorry about that. Okay, so hopefully that is a bit clearer now. I'll just make it a little bit bigger. Can you see all of that now? Is that okay, or has it gone back to a little bit?
No, we can see it all.
Great, thank you. Brilliant. Okay, so one of the ways you can find abbreviations is through Monash's legal abbreviations page. So I will copy and paste this into the chat in a minute, but it's basically guides.lib.monash.edu/legal-abbreviations. If you actually put in Monash legal abbreviations into Google, this comes up. Okay, so what you need to do is just literally use the index. So you click on C and then click on CL, and you can see that it provides you with the list of all the different abbreviations and what they represent. So there are some weird ones out there that you might not recognize, especially if you're looking at European or USA law report series, and you can also use this to find journal abbreviations as well. So keep scrolling down, it's a very long list. And you can see we're getting there now. So CLR, you can see here, has got various representations. So obviously we've got the Commonwealth Law Report series there, but note that it could also mean the Canada Law Reports if you were looking at Canadian cases. So there you can see that you can find what the abbreviations mean. And as I said before, it also includes things like law journals. So you see here CLJ is the Cambridge Law Journal. So that's one way of finding things if you're not sure. The other way is to go through the website, so in the library, and go to the law. So this is the Law Lib Guide in our library. And then, now I'm just trying to remember where it is now. Probably foreign law. Somewhere around here. It gives you access to the the Cardiff abbreviations guide. So I've just clicked on case law there. I've got a feeling it's at the bottom. Yeah, so here, so under case law, Cardiff Index to Legal Abbreviations, which is also a worldwide known one, and you type in your abbreviation there, and then it comes up with whatever it happens to be. But this one is not as comprehensive in the Australian context as the Monash one. So I recommend the Monash one. So this one doesn't always have law journals, and it doesn't have all the law journals, and it doesn't have all of the Australian materials in there. So you're better off using the Monash one. If you're looking for European materials though, this is really good. Okay, so I hope that helps you find what you need in terms of abbreviations. Okay, so let's let's go back to what we were talking about. So the case of Coco and Clark, excuse me, I still got a frog in my throat. So which legal database provides the electronic copy of the authorized law report series for this one? So what would be the authorized law report series for this particular case? Because there's quite a few different citations for this case, because it's been reported across a number of law report series.
The authorized copy would be the Commonwealth Law Reports, and they're on the Westlaw platform.
Yes, well done. Kat also noted that as well as Westlaw. So It's important to use the authorized law report series where it is available. Okay, that should be your first place to go when you're looking at a judgment. Those are the ones that are used in court. They're the ones that have been approved by the court as well. And it's partly based on history more than anything else, okay? It's based on that history of the way that judgments were collected by publishing houses and then produced into report series. But for now, we're still stuck with that authorized first. If it's not authorized, go for reported, because it's still going to probably be more accurate than the unauthorized, the unreported version. Okay, but yes, Westlaw, so Thomson Reuters, Westlaw is the Commonwealth Law Report series. So the full authorized version is available on Westlaw. Now, that doesn't mean that you won't find it in other formats on other legal databases, obviously. Now, did anyone struggle to find the case on Westlaw, Ostley, or Lexis, or did you find it pretty easy to locate? Because it's such a high-profile case, because it related to statutory interpretation and it related to human rights principles and the police, and also there's an element of conflict between the federal and the state. It features across all of those platforms quite easily. It's quite easy to locate it. Rebecca said, oh, tricky on Lexis. Okay, well, very quickly, I can show you how to find it on Lexis. So Lexis doesn't work quite, its search function works a little bit more different to Westlaw. Okay, so let's just go and find Lexis. Okay, so going to the library, going to databases. You can obviously go through the Law Lib guide as well. Lexis Advance. Hopefully it won't ask me for my login details. Just having a think. Okay, so you can use this big red box here. The problem with that is that it will search everything on Lexis. So here, you see this quick find menu here. You can pick cases, legislation, or secondary materials. It's a good idea to actually choose either case name or citation. So I'm just going to type Coco and the Queen in here. And what you can see is it's automatically populating the red box for me with a limiter. So it's actually saying you can search for Coco and the Queen, but only within the case name area. And then if we click search, hopefully, there we go, we should see we've got only one hit. And it's the right one because we can see it's the High Court, which is the one we're looking for. And then if we go through to that, then what we get is obviously confirmation that there is a CLR report, but we can't access that here because it's not published by Lexis. So the only version they can give us is the Australian Law Reports version, which is reported but not authorized. Okay, so then what you can see is you then get the sort of case-based data here. So we can see that there's been a lot of cases that have referred to the case, and some of that has been cautionary, some of it has been positive, and quite a lot of it has been neutral. Okay, so that's how we find that. Obviously, if you want to find the actual text of the judgment, you could go to the ALR reports, but you're better off in Westlaw where the authorized version is. Okay. All right, so what else have we got? Christopher Horn, Coco and the Crown came up easier than Coco and the Queen. Yeah, true. Yeah, and that just depends on how it's been entered into the databases in search terms. But it's actually, if you put in Coco, it would come up, but there might be other Cocos that come up as well, and then you'd have to cipher through and find the one with the right citation. Yeah, it just depends. Each database might be different. So Chris is saying, yeah, it comes up easier as crown in one than queen in the other. That's absolutely right. It depends on how they've coded that information in. Okay, so going back to what we were talking about. Where are we? So make sure when you're looking at case-base and first point and OSLE, in this instance, we had so many hits. I wasn't expecting you to write them all down, but you should be looking at least to identify the significant decisions. So has there been, for example, another High Court case on the point? Because that could have overruled it or distinguished it or explained how cocoa is an exception rather than the general rule. Has there been a high-level appellate decision in, say, Queensland, for example, on that point? Because again, that's going to help clarify the law. Your kind of district court, Supreme Court general cases aren't necessarily going to advance the law or change the law, although they might show you how cocoa has been applied, but they're not going to advance the law or change the law necessarily, because they're going to either have to distinguish or follow this binding cocoa High Court case unless and until cocoa is overruled. Okay, so when we note up the case in OSLE, I think, how many cases did you come up with? I think there were hundreds. Over 13 pages, Kat says. Yeah, absolutely. I think I counted 9. It said at the top of the search 926. Now, don't forget that OSLE puts that in order of relevance. So it's relevance according to what they think you're looking at it for. So the best thing that you can do at that point is switch to either looking at date order, because at least you're then getting it in the most recent first. So you'd be getting 2020 references first, which means that, I mean, the good thing about looking at the most recent case is that quite often they repeat what's happened to the law since cocoa, or they at least reference the important seminal cases since cocoa. What that means is that's going to help you kind of understand what's happened since cocoa, which is quite an old decision now. It's a 1990s decision. So sometimes looking at the most recent is actually a really good tactic, because it just helps you track that history of development. Now, not all cases. If they've distinguished cocoa, they might not go into a great amount of detail as to what's happened since. If they just go, this is not relevant on the facts, that might be the end of the discussion. But you might be able to find a most recent case where it's looking squarely at that point, or one of those points in cocoa, and it talks about what the Supreme Court of Appeal has done since in that jurisdiction, or maybe what even has happened across Australia. So yeah, either reorder it in terms of the most recent, which I showed you how to do last week, or go by database, because at least then you can identify the appellate court decisions, and you can identify journals that are connected to that decision that might be relevant. So in terms of academic commentary, there was also quite a lot in the OSLE area as well. Did anyone find anything really useful as part of this process that might be relevant to their research project? Not yet. Fair enough. I mean, it's quite a narrow case, really. If you're looking at listening devices, it's still relevant because the Act and the relevant section are still in operation. But if you're not looking at listening devices specifically, then it's probably only tangential to your project. It really only is connected to your project in the sense that it's just one of those random ad hoc ways that the system has tried to protect privacy. So you've got, trespass, and you've got stalking and harassment and all of that as criminal offences, and then you've got listening devices. But that's like the total sum of protection that's available. So it's really only tangential to your project if that's the case. Okay, what about looking at first point then? So were you guys comfortable in using first point? Yeah, good. Okay, so what was the most recent decision in the first point citation? I've raised this for a particular reason. Anyone have a look? All right, let's go and have a look ourselves. We'll go together. Okay, so let's just go very quickly to case-based just to show you. So this is where we left off. We were in Lexis and we were looking at Cocoa, and you'll see that down here we've got in date order, just here, sorry, cases referring to this case. And then you'll see in date order, the most recent one, which was the 10th of August, so very recent, is Commissioner of Police, and I'm not entirely sure how you say that name, Brodelo? So it's a Queensland Court of Appeal decision from 2020, so very recent, and there's a couple, in fact more than a couple. You'll see there's quite a few 2020 cases there. So there's quite a lot to work through. A lot of these will be relevant to admissibility and things like that, because they're relating to criminal cases. So quite a lot of recent cases there in the Lexis area. Let's have a look at Westlaw. So going back to the database search in the library. Okay, let's search for Cocoa. And you'll see that it's found it here. This is the right one again, look, that's the right CLR citation. So let's have a look at that. And we want to click on first point. So when we go through to that area, it doesn't give us the same information as Lexis. So we'll scroll down and you can see that's just the litigation history there. And then it gives you all of the information in the case first. So case-based does it in reverse. It gives you all of the recent citations, all of the cases that have distinguished or referred to the legislation, referred to the case, sorry, first, and then the detail about the case later, whereas it's in reverse in Westlaw. Eventually we get to cases citing, but you can see that the most recent decision here is a 2018 decision. Okay, so distinguished in 2018. And then it goes on. So it's not always in date order as well, because they categorize it. So they deal with distinguished first and then applied and then considered. Okay, so it's a little bit more tricky to find information. You can see we've got Burgess there, which appeared on the previous Lexis page, but we haven't got all of those 2020 decisions that we saw in the Lexis area. So what that means is to be completely thorough, there's some here, look, a couple of 2020 ones there. To be completely thorough, you actually need to be across both databases. Now, that might sound like a lot of work, but if you were advising your client and acting in relation to a point of law, so you're making a legal argument in court about something, then you've got to have all of the cases, right? You've got to have not just the most recent, but you need also the highest decisions as well, because you need to be able to obviously argue on behalf of your client, but also counter the other side's submission. So even if you've not looked at those cases, the other side might have. So you have to be across all of the decisions. So what I'm trying to say is that really fully comprehensive research requires you, unfortunately, to use both databases because they don't always produce identical results in their case citator features. Okay. All right, so let's carry on with what we were talking about. So in the first point feature, yeah.
May I just ask a question?
Sure.
Here? I'm sometimes uncertain about when to stop quoting cases, and what I mean by that is that if I'm writing about, say, unconscionable behavior or conduct, I would quote the authority of the Commonwealth Bank and Amadio. But then my question, having done that, which is the authority for unconscionable conduct, I must have some sort of reason for going on and exploring other cases, and I'm trying to clarify in my mind why that would need to be.
Yeah, okay, so it depends on what you're using it for, obviously, but Amadio is the seminal case. Okay, so that is really, although there were cases prior to that where there were discussions of unconscionable conduct, that is the case where it was agreed in the High Court that from this point onwards that this doctrine will always operate in relation to contractual arrangements, and this is how it's going to operate. So it sets out the parameters of the doctrine clearly for the first time. The problem is that then from that point onwards there have been a number of cases. So there's been, gosh, my mind's gone blank now. There's been cases like Thorne and Kennedy, the one with the, what's the name of the case that begins with K? So there's the gambling case as well, the casino case. There's been a number of cases where they have explored what is meant by taking advantage of someone in those situations as well. So with Lauf and Dipros, stuff like that. So you would need to cite those cases when you're really talking about how the law has evolved since Amadio. So there's been instances where they've broadened the scope even further. So Lauf and Dipros is an example of that. So they've gone to a situation where a relationship of emotional dependence suddenly falls within the scope of the doctrine, whereas that used to be within the traditional realm of undue influence. So what I'm trying to say is that when you're there are limbs within Armadio about what must be established to prove your case. Subsequent cases have gone on to explore and expand. Some of them are just exploring and telling you what is meant by those limbs, and some of them are really expanding Armadio even further or contracting it. You would need to talk about those when you're talking about what the law currently is, because the law is not identical to what it was in Armadio. It's evolved a little bit since then. And of course, if you're analysing the law, then talking about the way that it's either narrowed or broadened and who falls within its scope is actually part of the critique of that area of the law. Does that answer your question?
Yes, thank you, it does. How many years does it take to master that skill?
I'm still learning, hey.
So, in terms of our databases then, if I'm pursuing this thing about unconscionable conduct, I probably would be looking at cases where it's been distinguished or where it's been applied for the purposes of finding how my case might fit within the evolving doctrine. Is that correct?
Yeah, look, I think, again, it depends on what you're doing it for, but it's important to look at how the lower courts respond, because that can tell you, because there's always a gap between the High Court saying something and then it going back to the High Court for further clarification. So that can tell you what the trend is. And if there's a significant trend, it's likely that that is actually the law. I mean, it's likely that that will be the expansion of the law the next time it goes to the High Court, or the contraction. Okay, so it's important to look at those appellate decisions in the states and territories. It's also important to look at how it has been applied, because there could be an application of that is very similar to your factual scenario, in which case that's a good indicator of what's going to happen in your particular dispute. Interestingly, if you're critiquing the law, the way that it's been distinguished can be really relevant, because it shows you a dislike for that particular judgment, or that it practically doesn't work, okay, and it doesn't provide, or it doesn't hit its objectives. So looking at the way that it's been treated subsequently is just as important part of the process of critiquing the law as it is to actually read the seminal cases themselves. And I think what you'll find is that a lot of the journal articles do that. So they don't just discuss the theoretical basis of the original decision or even the subsequent visits to the High Court. They actually talk about what the ways that the lower courts treat those cases and apply them, distinguish them, etc. So, you know, take the tort of privacy. Some states have actually recognized a tort of privacy within their own jurisdiction, even though we're still yet to have clarification from the High Court. So, you know, that it's a very important part of the process of critiquing the law.
Yeah, thank you.
No worries. Okay, so first point feature, as I say, leads to a slightly different result data set to Lexis, which is why it's important to look at both. Obviously, when you're in practice, you work with whatever you've got. OSLI is always free. Hopefully your practice has at least one of the two, whether it's Westlaw or Lexis. But if they've got both, if you want to be super thorough, then you need to be across both. Now, there were a couple of journal articles mentioned in Lexis. For those of you that weren't here last week when we did legislation, I just want to show you now how to find those. Okay, so just, this is a bit repetitive, so it's okay for some of you if you just, you know, want to go and make yourself a cup of tea for a minute. But I just want to show those guys who missed it last week how to find a journal title in the library and find out whether there is either a hard copy or an electronic copy of it. So, for example, I'm just going to share my screen again. So let's just go back to the Westlaw page. So you can see right at the very bottom somewhere is a list of journal articles that have referred to Coco and the Clark in Westlaw. Now, let's say that I wanted to look at this one here. So Justice Mason, Human Rights, Interpretation, Declarations of Inconsistency and the Limits of Judicial Power. Now, if I click on that, what you'll see is that it only goes through to a summary, okay? So it only goes through to a summary because that particular journal article has not been published by Thomson Reuters, so it's not available in Westlaw. It's just an index of journal articles that have cited that particular case. Okay, so taking note that this is called the New Zealand Journal of Public and International Law, we can go to the library. Let's just go back to the main library page. And then when you're on the main library page, if you click on Advanced Search, and then go to the top and click on Journal Search, you can then type in the name of the journal. So it was New Zealand Journal of Public, whoops, can't type today, and International Law. And you can see that it comes up with an option for that. Now note that this is a bit sensitive, so sometimes you could type in the abbreviation, which in this case is NZJPIL, and it would come up with this. Sometimes it won't. So you're best off writing out the journal name in full, okay? Just so that you can identify. You don't need the. So if it's the Journal of blah blah and Society, then you don't need the word the, but you do need the full text. Now let's just click on this and have a look if it's available. And what should come up after it's had a little think about it, you see it's loading, is it tells you where within the electronic databases you can find that journal. So if we click on Hein Online, now note just before we do that it gives you from what date that's available. Now sometimes the relevant journal database has stopped stocking that journal from a particular point in time. So you need to check the date complies with the date that you're looking for. But in this case, they've both been available since 2003. And then if you click and go through to Hein Online, I'll have a little headache about it. You can see that we've got a list of the issues for this particular journal, and we were looking for issue 11. So if we click on 11, and you'll see, was it number 11? I can't remember now. No, sorry, it was 2011 we were looking for. My brain's not working today. So issue 9. And you can see here, human rights interpretation, declarations, and inconsistency. So if you click on the little icon there, that will give you the full text in PDF format. Okay. So just a little tip there for finding journal articles through the library. Okay, so let me just close that. So see what is next on my list. All right, so, and again, if you got a journal abbreviation in Lexis or Westlaw and you didn't know what it stood for, you can go to that Monash page and work that out. Okay, so if you typed in NZJPIL into that Monash, well, if you searched under N in that Monash area, you would actually find that it stands for the New Zealand Journal of Public and International Law. Okay, so we've looked very briefly at the case-based feature already, and there were lots and lots of journal articles that came up in the case-based area, quite a few more than in Westlaw. So again, that's showing that difference between the two databases and why it's really helpful to be across both of them as part of your research. Now, I know we came up with way too much information for you guys to process with this case, but if you were looking at an important case and it came up with, say, 10 cases for you to look at, which one would you read first and why? There's no right answer, it's not a trick question. Well, your options are you could start with the most recent, you could start with the highest authority, you could start with the earliest in time. Okay, so Rebecca says High Court decision if there is one. Absolutely, you could go with the highest. That would at least give you confirmation of the law on a particular point. Stephanie says most recent. That can also be useful because if it tracks the law, then you can get the development in one snapshot. Almost a bit like a textbook, I guess. Kat says the one that was applied, not considered. Yeah, good. Another good way of screening is to say, okay, I think distinguished and considered cases are important, but the ones that have applied the law are going to tell me a lot more about what happens in practice. So all of those are great ideas, focusing on trying to get to the crux and the background information that you need as quickly as possible. Now, in addition to that, it's important to make sure, though, that you are reading the minority views as well as the majority ones if there is a split in the court, because at this stage, we're not just trying to find out what the law is, we're trying to analyze the law. You know, the research project is geared towards critiquing the law, working out on a practical level what works and what doesn't, on a theoretical level what is problematic or what works. And one of the ways that you gain that information is by engaging with minority decisions. Quite often, they present very sound reasoning as to why the majority view is problematic. So sometimes it can just be on the application of the law to the facts that they disagree, but in some cases they can provide quite a lot of critique. So it's not just journal articles that you're looking for, minority views can also be really helpful in that critique of the law as well. So just to see how useful it was, this particular task, just going to run a poll now, which is, will Coco and the Queen feature in your research project? Yes or no? Completely anonymous. Zoe says, I need a maybe button. There's always one, Zoe. If it's not a yes, it's probably a no, I think. All right, just waiting for a few more of you to vote. Okay, closing the poll now. All right, so let's share the results. So about 33% of you said it would feature in your research project. The vast majority of you said no, and that's probably because, so 67% said no. I think that's probably because, as I say, it's quite a narrow topic, although it features quite heavily in the issues paper, because in the issues paper, they're trying to outline what the current state of the law is. So what current privacy protection exists. And really the issues paper concludes that it's sort of this sporadic ad hoc protection that's just developed over time in this sort of chaotic way. So it features quite heavily in the issues paper, and that's why I picked it, because you keep reading it as you're reading the issues paper, but it's on quite a narrow topic in terms of listening devices and monitoring phone conversations, etc. Okay, but the exercise is still an important one, because we have to think about what we do with the information when we've read that case. So how do you guys go about taking notes on cases when you read them? What's your process? Again, no right answer, I'm just interested to find out. Amy says it depends. Zoe, find the decisions of each judge first, then read through. Okay, yeah, absolutely. I mean, in this instance, they were actually all agreed, but just for slightly different reasons. But sometimes you do want to work out who's in the minority straight away, so that the notes that you take are focused on that division between the two camps. Okay, so Stephanie says, write down anything important that stands out and add the pinpoint reference so I can go back to it. That's a really good tip, Stephanie. So if you're referring to a particular part of the case and you think, oh, that's really helpful, even if you don't quote it directly, noting the pinpoint reference and summarizing what that section says, and then noting the pinpoint reference, means that you can either just take that summary and put it into your research project and you've already got your citation sorted with your pinpoint, or alternatively, it's just a reference point for you to immediately find what you need if you need to go back and read the case later. So both of those are really good techniques. I think case notes feel like sometimes like they're a bit of a waste of time, but they can be really useful in this process, because what they do is they get you to focus on the issues, focus on the important facts, not all of the facts, but the important facts, because you've got to condense them down and make a summary of the pertinent facts. By focusing on the issue, that actually focuses your mind on what facts to include, because you only want the facts that are relevant to the issues that you're looking at. And then when you've got the issues feed into the ratio or the reasoning, okay? Because the ratio is the answer to the issue. So issues are normally phrased as questions for the court to determine. The parties try and put them into questions to assist the court. So quite often you'll submit a list of issues, and you might even agree the issues with with your opponent in advance. Okay, so you have a list of issues. The court has a list of issues to determine, and they're phrased as a question, and then the ratio is the answer to that question. Okay, so it's not just a yes or no, it's a yes and here's why, or no and here's why. So clearly articulating the issues in some form in your notes, whether it's a case note or otherwise, actually helps you find the important reasoning in the case. Now, of course, you can look at a case and there could be 8 issues. You might look at a tax case and you're looking at it for an statutory interpretation reason, but it's got 7 issues on tax law, tax principles, and 1 issue on the interpretation of the relevant provision. For your purposes, you don't need to write down all 8 issues. You can just write down the 1 issue that's important to you. You still need to read the case, because you need to understand the context, but it makes your note-taking easier because you can just focus on the bit that you need it for and focus on the reasoning that's connected to that particular issue. So case notes, or a sort of watered down or amended version of a case note, can be quite helpful in terms of identifying the important parts of the case that you're going to then use subsequently in your research project. Now, in terms of the key issues in COCO, there were 3 key issues. Does anyone know what they are? I don't know whether you heard that. My little dog is crying at the door, wants to come in. I've just rescued her. She's only like been here 3 days.
Well, one of the issues was about the construction of S43 in the Invasion, the Privacy Act. That was the first one.
Yeah, absolutely. So whether or not the relevant section provided the judge with the ability, the authority to authorize entry into premises where the entry is via trespass or in the circumstances of trespass. Okay, so the wording of section 43 talks about use of the listening device but doesn't mention installation. So what happened in this case was that the federal police pretended to be telephone agents, you know, like of Telstra or something like that, went in and said that the line was faulty. And then while they were there, put the listening device into the premises that COCO's business was operated on. There's a prohibition from the use of listening devices under the Act unless you fall within one of the exceptions. And the exception of section 43 is where you have been authorised to do so, or where the Commissioner of Police has been or an inspector has been authorised to do so by a judge. And there are a range of considerations that the judge needs to take into account. In this instance, though, the wording only says that the judge can authorise use of the listening device. So again, it doesn't use the word install. So in that context, the question is it implied, in essence, that you can go in in circumstances of trespass to install the listening device in order to be able to use it? Okay. And then following on from that, and that's quite often what we see is we've got a primary issue here, and then there are actually sub-issues. So following on from that, if such authority cannot be granted by the judge, so if the judge cannot grant authority to enter in circumstances of trespass and install the listening device, is the use of the listening device invalid? Does it invalidate the authorization? And if the approval is void, so again, that's all conditional upon the answer to the first one. Okay, so depending on the answer to the first one, the court might not even need to go on to 2 and 3. The third issue is if the approval is void, did the Australian Federal Police not require approval because of a section under Section 12 of the Federal Police Act 1979. That particular provision says that the intention of that provision is that federal police don't have to do anything more than that which would be required of a state federal police officer. Okay, so it's about that conflict between the federal and the state zones. So, for example, it's a silly example, but a federal police officer doesn't need a state driving license to be able to perform those state-based activities. Okay, they are deemed to have them. Okay, so what did the majority say about the interference with fundamental common law rights? How was the concept of a fundamental common law right relevant to their interpretation of the statute?
Can I speak again?
Absolutely.
Well, the reason is that a fundamental human right can't be ignored or denied unless the legislature has made clear in its legislation that that right is going to be overridden by the legislation. So the right here was really protected in that piece of well, the right wasn't protected in the legislation, but the legislation didn't authorize the denial of that right.
Yes, absolutely. So a couple of points to note about that, which is that we're talking about a fundamental common law right, not a human right. They didn't phrase it really in those terms. Okay, so there are, universal human rights, but they mean nothing unless they're incorporated into domestic legislation. So Australia has signed numerous treaties about human rights and has only incorporated a fraction of those human rights into treaties. Okay, so that's the first point, which is that, so they're not talking about a human right concept, okay, but they're talking about a fundamental common law right. This right to be able to exclude people from your premises when you are the occupier has been a consistent right since the concept of trespass was invented hundreds of years ago. And so their approach was that it underlies the entire basis of the concept of trespass, right? So their point was that when you've got something enshrined in the common law, this right that's enshrined in the common law, the Parliament must expressly indicate that that right has been interfered with, okay, that it's been taken away or reduced. Now, they talk about the fact that express language would usually be seen, would usually indicate that. However, it can occur by implication as well. But the implication has to be unambiguously clear. Okay, so it's not just, oh, well, don't be silly. If they've used the word use listening device, then it must include installation as well. That implication wasn't strong enough. Okay, it would require something, I think it might have been Toohey, but it could have been Dean or Dawson, the later judgments, where they gave an example of the definition of listening device would have to include reference to covert. So if it said a listening device is a device that blah, blah, blah has been installed in covertly or overtly, that would tell you that covert was allowed, which meant that trespass was allowed. But in the absence of a clear indication, in the context of the statute. So you could look elsewhere, you could look outside of section 43, but in the absence of a clear indication in the statute, then it was presumed that that fundamental right to exclude others from your premises remained intact and had been unaffected by what Parliament had legislated. So why are we talking about this? Because there's lots of this kind of stuff happening across the interpretation of legislation, and it might even be relevant to other cases that you're looking at in other contexts. So, if you're looking at the regulation of drones, if you're looking at the use of GPS tracking, you might want to think about whether some of the fundamental common law rights like these will prevent the operation of those relevant provisions, or whether they strengthen the privacy whether they strengthen the privacy position of the individual. So just be mindful of that kind of movement and flexibility in the law even when it comes to interpreting legislative provisions. Now, finally, the court, just to sort of bring it all to a close for you guys. So of the three issues, the court also said whether or not the entire order allowing the federal police to use the listening device was invalid depends on the context. In this context, you couldn't sever the judge's wrong interpretation of the law, thinking that installation was allowed as well as use. You couldn't sever the two. It all formed part of the same decision. So the entire court order was invalid. And that meant, consequently, that the evidence gathered by the listening device was inadmissible, and therefore the whole trial process was problematic, and a new trial would be needed. The question is the minority view, so not the minority, but in this case, Dean and Dawson gave a separate judgment, and so did Toohey. So 3 judges gave separate judgments. Sorry, Dean and Dawson were together, and then Toohey was separate. In that instance, were any of those judgments of any assistance, do you think, in critiquing or analysing the law? Well, in this instance, those separate judgments still agreed with the outcome. They all agreed that the appeal should be allowed. And Dean and Dawson specifically say, we agree with the comments of the plurality. I can't speak today. Okay, they agree with that decision, but they wanted to add some additional comments. Toohey just gave additional reasons that expanded upon the other judgments. So in all cases, they don't really provide an analysis or critique of the law beyond really what we see in the decision. But they do give other examples of how that legislation could be interpreted. So if you are looking at interpretation, it might be helpful, but in terms of its value for critique of the law, then these separate judgments, because they're not in the minority, they all agree, right? They're not actually minority. But these separate judgments aren't particularly helpful. But occasionally you get some real crackers. Justice Kirby obviously always used to produce wonderful dissenting judgments, but there's quite often one that really goes out there and analyzes the law and explains why it's problematic. Okay, so if you did a case note for this, then just to give you an idea of how long it should be, anything more than 2 pages is way too long. Okay, you need to be summarizing that information as much as possible. So for the facts, for example, my summary of the facts, I got 79 words. Because what I did was I actually wrote a bit more than that, but then when I identified what the issues were, I went back and chopped the facts down until it was a smaller summary. And then for the reasons, because I wanted a broad understanding of each of the 3 issues and I wasn't just focusing on one, then there was a bit more there. But if you were just focusing on one issue, you could really just look at the ratio, or you could look at the ratio and then some discussions of how that law, if they've gone on to say, in the future the law might do this, or this is how we would apply it in other situations, that might be quite helpful. Because there was no critical analysis that was really useful, again, that made the case note a bit shorter. Michael says, what's the case again? Oh, it's Coco and the Queen.
Nicole, may I just ask a question about some of the language that's used in that case that left me a little bit in doubt? When they speak about Carter in the lower court making a jurisdictional error, do they mean by that not that he didn't have the authority to hear the case, but that he misinterpreted the legislation? Is that what they mean?
Yes. So when the order was made, it was broader than the power conferred on Carter allowed. So because the statute only covered use of the listening device and didn't cover installation, and Carter's order mentions installation, it's badly worded, and that's one of the things that they pick up on that order is there's actually a section of text missing from it. But aside from that, they still say it's focused on installation as well as use. Justice Carter mistakenly thought that installation, whether it's by implication or otherwise, installation was permitted under, he was permitted to order that under the Act. Yeah. Okay. All right, so that brings me to the end of this week. Any questions about any of the content that we have covered? No? Any questions about the project plan that's due tomorrow? Nope. Okay, any other general questions before we say goodnight and you guys are one step closer towards your lecture recess? Oh yes, Kat, sorry, you're quite right. So apparently, Kat wrote to me earlier today and said that the Law Society have not had enough expressions of interest in the mooting competition that's being run. It's apparently only $30 to go into the competition. You'll need to join the Law Society to be able to participate, which I think is $10. But because they haven't had sufficient candidates, it's possibly not going to run. So if you are inclined to practice or hone your advocacy skills, this is going to be a great opportunity to get into that team and do some mooting. It's possibly, you know, a little bit challenging because you guys are all really busy at the moment, but those kind of extracurricular activities are always beneficial in terms of skill development, guarantee that you will learn a lot in that process, and it obviously looks good on the CV as well. And Kat says, John Milburn is the coach, and we need more people. So if you're interested, please maybe get in touch with Kat. I'm sure Kat wouldn't mind. But please make sure that you make contact with the Law Society and express your interest before it's too late. Okay, so that's it for this week. I will be around lecture recess, so feel free to still message me on chat in MS Teams if you like. I can also do some student consults if you start researching on your topic and get into a bit of a panic. I have 150 odd project plans to mark, so I will get them back to you, and I'm doing it solely on my own. So I will get them back to you as soon as is humanly possible, but I would like to sleep, so I will also, there will be a bit of delay getting them back to you. But as I say, feedback opportunity, so please let me know if you've got any particular questions in the actual project plan itself, and I will certainly answer or address them. Kat says, CQ Uni Law Society on Facebook, or you can contact Isabel Forsyth on CQU email. Okay, so that's how you can find out more information on the mooting stuff. Okay, that's it. Have a great lecture recess. I will see you in week 6. Bye, everybody.
Thank you.
Thank you.